Good morning, everyone. I'm going to really focus in on this slide, but before I get started, I just want to give a little bit of background. One of the reasons I actually put all the four enforcement branches in there is to more or less talk about the fact that I know competition, I know what I know, but I don't know necessarily how it specifically interfaces with RIPRA. Obviously, Pat and I had talked yesterday in brief for a brief point, but tried to pick up on a few things this morning. It's quite fascinating. I think I also want to start by just giving you a sense of the overall ecosystem that the competition ecosystem plays out. We have the Competition Bureau, we have the Competition Tribunal. There are various components in there, but I think I'll start with the ecosystem. I want to talk about the investigatory process a little bit, but then I really do want to do a little bit, as much as I can, a deep dive into each of the enforcement branches. The key takeaway is I'm going to give you a lot of information and a snapshot of what the Bureau does. At some point, maybe throughout, whether you're dealing with the various players in your industry, something might trigger something you might have heard today. You say, oh, that sounds like something Roger talked about. Maybe I should reach out either to RIPRA or to the Bureau or to me directly and say, oh, we may have an issue under one of the branches, or this is something that we might want to talk to your advocacy group about, because it goes specifically to the competitiveness of the market. But very quickly, so the Competition Bureau, well, maybe I'll even start before that with the Competition Act. The Competition Act is an act of general application, so it's not regulatory specific to one industry, but covers all industries and generally dovetails, I think, to a certain extent with what Pat was saying with your own regulatory regime. What's interesting about it is that it's, call it bifurcated in a hybrid act, in that it has both civil provisions as well as criminal provisions or criminal offenses, but also in that the commissioner himself at the Bureau doesn't have the whipped hand to actually, similar to potentially the registry, to actually put out compliance orders or AMPs. We have to go before the Competition Tribunal, at least on the civil side, to prove the case, and the order comes from the tribunal. So there is a process that's in place, hence we're the investigators at the Bureau. The tribunal is the adjudicator, which to a certain extent might have similar powers to what I heard today about the Environmental Review Tribunal, except they're the primary issuer of the order. So all that to say, I think the major takeaway there is that the Bureau might think they have a really good case, and they might, which is usually based on a complaint that may come from an industry, but at the same time, that's not the end game. We still have to build the case and bring it before the Competition Tribunal. Similarly, a similar thing has to happen if a prosecution takes place under the criminal provisions. So maybe I'll just take 2 seconds and talk about the investigatory process, just so you're generally aware of it. Most of our matters or investigations actually take place, are complaint-driven. We do have an outreach program, we do have a promotion program, but for the vast majority, the market does talk to us. If something's not working, it's always one of those things that if you're feeling the pain, you will reach out, and that's where we start investigating. We start out mostly by just contacting the players in the market to focus in on some of the key competitive issues. The two main ones that we always look at are what are the barriers to entry into a certain trade level, and in particular, are there any effective remaining competition that could actually discipline the market? And we'll get into a little bit more into that. I might give you a mini case study, or not even a case study, but an example of what I mean by that. But the next step is we contact the market on a voluntary basis. If we feel that there's something there, if there's something that, feel that there is a real concern, the Bureau would go, or the Commissioner would go on inquiry. That's a key step. It's a trigger. Once we're on inquiry, we can actually apply to the federal court to get orders to compel. And that basically it's effectively a subpoena, but it's a subpoena, and it can be on 3 levels. We can bring people in to actually interrogate them or investigate them on the record. We can ask for records that are in your possession, or we can actually ask you to fill out what we call an information request, and basically give us a narrative of what we're looking for. Assume that if we keep going down this path, that we've done the market contact, voluntary information has come in, we've got the information through Section 11, is the provision under the Act that's key, and then what happens next? Assume that we actually feel that there's something problematic in a market. 2 paths, effectively. One, and you'll see this often, we get settlements that actually arise when we start discussing things with whoever is the target of our complaint. And now I'm really focusing mostly on the civil side of things, because that's more or less where I work into. Assuming we get some sort of a settlement on its own doesn't have that much enforcement. We actually register it with the competition tribunal. Upon registry, it actually has the same power as if it was a competition tribunal order. What's key there is, because it's an order, if there's any infringement of that order, we, the Bureau, would go before the tribunal and seek to have that provision or breach enforced. The other aspect of it is obvious, as I've alluded to already, is we would build a case and bring it before the competition tribunal. That's a full proceeding, a full litigated proceeding before the competition tribunal. The competition tribunal is actually a specialized tribunal. They're an admin law tribunal. However, they are closer to the court end of the spectrum, because they actually have federal court judges that sit on the tribunal, as well as they seem to hire lay members that are PhD economists and others that have a certain level of specialization in industrial organization or economics. In any event, I just want to leave you with the concept, as I said, that one is the settlement process, two is the litigated process, and as anybody that's ever gone through litigation, you may have the best case, but at the same time, at the end of the day, judges are judges, and they may not agree with you always. And we could go through the various levels of appeal. It goes from the competition tribunal directly to the Federal Court of Appeal, and then directly to the Supreme Court. And it does seem like we have an inordinate amount of our cases, given the bet the firm type of scenarios that we have in them, that actually end up going to the Supreme Court. So in any event, let me just jump into the four enforcement branches, and don't let me forget at the end, in addition to the four enforcement branches, the advocacy branch is a key branch. It's not necessarily an enforcement branch, but it is the branch that generally has been the interface with RIPRA. Rather than waiting till the end in case I forget them, they're the ones that are out there just promoting enforcement or promoting competition. They do so by ways of submissions to various regulatory bodies. They actually would work with a potential regulator I think there is a couple of slides there that are talking about, they do market studies, white papers, regulatory interventions, and they have a paper called the Competition Advocate that they put out there. The one that was quite, let me see if we have it there. There was one in particular, I'm not sure if it's in the slide, you can't zoom in on it, but a very good example that I always, as you can imagine, competition law isn't the sexiest topic, but every once in a while at a party somebody asks me what we did on the Uber front. And in that regard, the Bureau put in a letter to the City of Toronto talking about the modernization of the taxi industry. It isn't Uber specific, but it does seem to, if there's a fledgling new industry, something that's moving quickly, we want to make sure that there's an equal playing field across the board, and stuff like that has actually seemed to really resonate with the various regulators that are searching to figure out what the best scenario is for maintaining a competitive market. But let me just go back, because I do want to at least touch on all four branches, just because I think there is some applicability, or potential applicability, I should say, for your industry. I'll start off with the mergers branch, just because it is the easiest and the most straightforward, and I might try to figure out if there's a scenario where it might alert, it might actually interface directly. The mergers branch is basically a notifiable branch. If you have a merger that meets a certain threshold, then you have to notify the Bureau. You can't close until the waiting periods have transpired. What's interesting here, and this is where I'm trying to relate it to what I heard this morning and relate it specifically to your industry. If there's a service provider, for instance, that is actually merging with another service provider, they're purchasing another service provider. I always use, let me back up and give you a little bit of context. My wife is a competition lawyer, and so you can imagine our lives are a little bit difficult because I'm at the regulator. So I always use the Coke-Pepsi scenario. If Coke is buying Pepsi, and the can of Coke or a can of pop or soda that is usually $1 is going to likely raise to $2. That's where likely the Bureau would intervene and say, okay, this merger is anti-competitive, we can't let it happen. To finish it off, I would be at the regulator, and she would actually be representing Coke or Pepsi. So we seem to have these arguments as to what's right and what's wrong often. Luckily, there is conflict wall, so we don't actually work on the same files, but there's sufficient level of conflict anyway. But that's the type of merger that you're looking at. And so to put it to your context, if there's a service provider that's providing you a service and today it's costing $1 and tomorrow they're merging with another service provider, likely your next best substitute. If your first service provider, and I don't really care what the service provider is providing, what the service is, but you use them regularly and there's another one that you use as your option 2, and there's only, let's say, 3 options, but because number 1 and number 2 are merging and there's a potential, or you're concerned that there's going to be a potential, whether it's a decrease in the quality of service that's going to be provided to you or a price effect, then that's something that either you may want to raise it to our attention, or the Bureau may actually proactively, assuming it's a notifiable case, may look to contact you to figure out, do you have concerns with this merger or not have concerns with this merger? As I said, the 2 key criteria that we look at are barriers to entry. How hard is it for another service provider to enter into that space if there's no barriers to entry because it's something easy to get, it's a piece of land is their main thing and a little bit of sunk cost, then they can move into it. If it's a high barrier to entry, so you don't think even through this merger another player might enter, then there might be more and more concerns. Deceptive marketing practices, I think, is an interesting enforcement branch. I haven't done a ton of work in this space, but where I want to get into, this is obviously all about misleading advertising, but that has it's almost like an umbrella statement. It falls under, some of the subsets under there are ordinary selling prices, performance claims, and what right now one of the major focuses is drip pricing. I'll just sort of zero in on that last one because it is a priority for us. And it's actually, you've seen it all the time. More or less, if something is advertised, it's $9.99, but then you go click on it and you go to try to buy it for $9.99, but there's a bunch of other mandatory costs associated with getting the service or the product. And so the $9.99 really ends up being $15. That's the drip pricing because you keep adding little things along the way. What we're trying to say is the advertised price should be the price that you can actually buy it for without all the mandatory prices. I'll go to cartels next, just because it's a hardcore provision. Maybe I'll just touch on it. The deceptive marketing, given the extent of the anti-competitive behavior, is one of these dual track type of provisions. It could be taken civilly or it could be considered a criminal offense. So it's one of those ones that's a little bit depends on the nature of the conduct. Cartels is your run-of-the-mill smoke-filled room. A bunch of suppliers are sitting around and they're deciding what the price should be in the market, or they're saying, well, I'll take everything east of the river, you take everything west of the river, and then you sort of split the market up. Obviously, we have serious concerns with those. It's a criminal provision, heavy fines. I will mention this: if there is this type of behavior and you're privy to it, one of the things that this isn't a pitch for it because I'm hoping this is the ounce of prevention as opposed to the pound of cure, but we do have an immunity program as well as a leniency program. First person in, it's effectively like a whistleblower, basically gets more or less a free ride as long as they cooperate with the Bureau, and that information goes to actually rounding out everybody else as part of the cartel. And finally, is my division, the Monopolistic Practices group. I can't stand that phraseology. I just call it anti-monopolization. But here, and it's what I'll mention here, it's a 3-part test. And we, the Bureau, if we ever bring an application before the tribunal, have to meet all 3 elements. And there's actually a sub-element that's key. But I think the disclaimer we always say for this, being big isn't necessarily bad. It's that you're necessarily dominant in a certain market, and that you have conduct that is actually having a predatory, exclusionary, or discriminatory effect on a competitor. And so those 2 are key, but the third is that it's actually having an effect on the market. And we have to prove all 3. If we miss our shot on all 3, the tribunal will shut the door on us. The sub-element, and this is really getting to the weeds a bit, but if this conduct is actually being done for a legitimate business expectation that's pro-competitive, which is almost like a defense, then it's possible that the court may see that outweighs the actual conduct and the effect of the conduct. In any event, that's the Bureau in a nutshell. I've given you a snapshot of all 4. Rather than take questions, I'm happy to take questions. I'm mindful of the time, but I am going to stay till noon, and if you want to grab me and talk to me about something specific, a little bit more one-on-one as opposed to in front of all your potential competitors, feel free to buttonhole me out in the side or wherever it would be. But I'm open to questions if you have any. Thanks so much.